Hello and welcome to this special edition webcast with Pro Bono Partnership of Atlanta. I'm Sarisha Gunta, Education Director with PBPA, and our speaker today is Robin Miller, who will be speaking to us about recent changes to the Nonprofit Code of Georgia and how those changes might impact your nonprofit. But before Robin gets into the substance of today's presentation, I would like to share some background on PBPA and our mission. The Pro Bono Partnership of Atlanta provides free business legal services to Atlanta area nonprofits. We do this by connecting nonprofits with volunteer attorneys who are from Atlanta's leading law firms and corporations. PBPA provides direct legal services to our clients, and we also provide free resources through our website to any interested nonprofit. Our clients are 501c3 organizations serving the greater Atlanta area, and they serve low-income or disadvantaged individuals. Our clients are otherwise unable to afford legal services. If you're interested in applying to be a client or for more information in general about PBPA, please visit our website. And also on our website, we have a great deal of information that's available for free to any nonprofit that's interested. This includes articles, workshops, webcasts, and podcasts. And also a little bit of housekeeping before we start with Robin's presentation. Today, Robin will be answering general questions. We ask you to please drop those in the Q&A during the presentation. But keep in mind that what Robin will be sharing with you today is general information. It's not legal counsel. So if you have specific questions, please reach out directly to an attorney for your nonprofit. And today's presentation is being recorded. The recording and the slides will be available on our website next week. And now I'd like to introduce our speaker. Robin Miller has more than 30 years of corporate and tax-exempt law experience between two law firms, Ernst & Young, and here at PBPA. At PBPA, as Senior Corporate and Tax Counsel, Robin acts as outside general counsel for over 300 nonprofits, provides corporate tax legal advice to many of PBPA's nonprofit organizations, and she leads our legal checkup clinics. Robin is a member of the Atlanta Bar Tax Section, and she's the past chair of the Georgia Bar Nonprofit Law Section. On top of all of this, Robin led the legislative committee to get the updates to the Nonprofit Code of Georgia, the ones that she'll be discussing today. Who better to talk to us about these changes to the law than the head of that committee who's done it all? So let me hand the Zoom over to Robin.
Thank you so much, Sarisha. I appreciate it. Well, welcome everyone. I appreciate you all being here. We've got a lot to cover, and please do drop in questions in the Q&A, and we'll try to answer them as we go along. As Sarisha mentioned, I had the honor of leading a committee of amazing nonprofit corporate experts in Georgia for 3 years to draft the amended Nonprofit Corporation Code. It was passed by the legislature in March, signed by the governor in May, and became effective July 1st. The entire code was amended. The legislation itself is 300 and some pages long. So obviously we can't cover all of that today. So that's not our goal. Our goal is to understand how changes affect the operations of our clients and of small nonprofit organizations, particularly related to the board of directors, officers, and members, if the organization has members. So we're not going to do a complete review of the Georgia Nonprofit Corporation Code. We're going to do an overview of the major changes in the code. And our focus, again, is on these operational activities of the nonprofit. So we're not going to review changes to things like the merger section, dissolution, foreign corporations, or other provisions that are not day to day. On the next slide, you'll see our agenda. It's quite a lengthy list of items, and I'm going to try and get through them as quickly as I can. I'm only highlighting the changes. I'm not going to explain what the law is in all of these areas. I want to first begin with definition changes. So there were a number of definition changes that were made, but the few that I really want to highlight today are the change to the definition of delegate, and really it was a clarification. We found that there was a lot of confusion around what constitutes a delegate. So just because you're a delegate doesn't mean you're a member. And for a delegate to be a member, it has to be specifically stated in the articles or bylaws. So we wanted that to be really clearly explained. We have a new definition for Chief Executive Officer and Chief Financial Officer, and we will be going over that a little bit later in the presentation. In addition, one of the major goals of the committee was to modernize the code. The code hadn't really been changed significantly since 1991. And so we decided it was time to take out the word telex from the code and a few other ancient types of electronic connections. So we've updated the definition of document, electronic, and electronic network to match with how we actually operate in today's world, and hopefully to continue with what the future will hold. All right, now let's turn to directors and director meetings. And there's a lot to unpack here, so I'm going to kind of run through it, but hopefully you can, there's a lot of just specific details. And these are important to know because it may affect what you have in your bylaws or in your articles of incorporation. And that is really the goal today, to highlight those areas where you might need to make some changes. So any corporation created after July 1st, 2023, that does not have members must have at least 3 directors. That probably didn't apply to any of you. You all have probably been in existence for quite some time. But the reason for that is because we don't want, if there's no members and there's just 1 or 2 directors, you could run into a problem of incapacitation and suddenly you have no directors. And that creates a lot of issues. This is more particularly true with private foundations than with public charities, but it does happen with public charities as well. So even if you were created before July 1st, the best practice is to have at least 3 directors, regardless of when you were incorporated. We've also added to the code was that if there are no directors in a non-membership corporation, the Attorney General or any interested person can now go into court and have at least 3 directors appointed. Whereas in the past, it was very difficult to get that resolved. For those organizations that are membership corporations, if there are classes of members, directors can now be elected by specific member classes. So you might have Class A that elects 3 directors, Class B that elects a different 3 directors, and so on. Directors can always resign, and there's provisions in the code for that, but now they can also condition their resignation upon the happening of an event. But that resignation is not revocable, but it can be done. Next, I want to talk about another provision of the Georgia Code, and that is Section 51-1-20. And it generally provides immunity from civil liability for acts or omissions arising out of a volunteer service to a nonprofit. Most directors in nonprofits in Georgia are volunteers. They're not getting paid for their service as a director. And it was not clear in the code that this provision applied to nonprofit directors. Well, now it is clear, and it does apply. Of course, the director has to have been acting in good faith in order to have that immunity. Does that mean that you should not have directors and officers liability insurance? No, it's still recommended. And you need to think about the impact of if you have a director who is in fact paid. And I don't mean reimbursement for expenses, but actually paid in their service as a director. I will say the same provision was also added in connection with officers. But of course, for officers, it gets a little bit more confusing because many times officers are paid, and so then this wouldn't apply. So again, if you have an unpaid officer, if your officers are directors who are unpaid, then this would apply for their officer duties as well as their director duties. All right. Now let's talk for a few minutes about director meetings. So the code was not really very clear about the difference between a regular and a special meeting. So that was clarified. So a regular meeting are those that are fixed. They're either, it's in the bylaws. Maybe you meet once a month. Maybe you meet quarterly. And then maybe the board passes a resolution that says, okay, we meet on the third Thursday of the month at 5 p.m. at such and such location. That is your regular meeting, and it can be set in that normal process by the bylaws or by board resolution. All other meetings are technically special meetings. And special meetings can be called by the chair, the CEO, or at least 20 of the directors. 20% of the directors, I should say, not 20. And that was an important clarification. Now, directors or boards can also have actions without a meeting. And there have been a few changes or updates that have been made in that area. A director can now revoke their vote prior to the last written action needed for the vote. So let's say you have 10 board members or directors, and there's a vote being cast, and let's say you vote second. Well, until they get up to 6 votes, one way or another, you can revoke your vote and submit a different vote, or not vote at all, as the case may be. But once that final vote that determines the result is in, you cannot revoke. Next, and this is again that modernization factor, signatures for actions without a meeting can now be manual, by facsimile, although most people don't use faxes anymore, conformed, or electronic. So lots of different ways to submit a signature, making it much easier for them to be accepted and to get things done. The new code has some specific notice requirements that are new. And that is if there's a vote to modify or amend the articles or bylaws or to remove a director, the notice for that meeting where that's going to take place must specifically say that these actions are going to take place. However, your articles or bylaws may say, no, we don't have to require notice of this. And then you don't have to. One thing I should note in general about the Georgia Nonprofit Corporation Code is that it is really flexible. And it allows for, a lot of times you see provisions that say, unless the articles or bylaws provide otherwise. And that's because the Georgia Business Code and the Georgia Nonprofit Code are designed to be flexible and to meet the needs of the organization. So where those provisions don't say that, then it's not so flexible. An additional flexible option that was added in was oral notice of meetings. It's permitted if your articles and bylaws say it's permitted. So if an organization chooses to allow for oral notice of meetings, and that's something to think about very clearly, whether that makes sense and whether it's going to cause any potential issues or problems with your organization. But if it won't, and it's a good idea, then it needs to be added to your articles or bylaws, and then notice can be oral. And that may be a common thing for special meetings or things like that, where it's they're usually happen in a short period of time. One of the biggest changes to the code is that no director shall vote by proxy. And that's really, that was when the committee discussed this, it was very clear that everyone agreed that there should be no voting by a director by proxy, because frankly, it's a violation of the duty of care, the fiduciary duty of care of every director. A director has a fiduciary duty of care to make sure that any decision that a director makes, is based on facts and information and participating. So attending that meeting is important. If there's a decision to be made, that director should be in attendance to hear what the issues are, hear the discussion, and make an educated decision. And so having a proxy vote does not allow for that educated decision to be made. Moving on now to board committees. So board committees is an area that's often confusing, or has been confusing to a lot of organizations. People often think of, well, there's standing committees, and there's advisory committees, and there's ad hoc committees. And the code actually doesn't talk about those kinds of definitions. What the code talks about is committees that can exercise authority for the board of directors and those that can't. So what we did was we tried to clarify the different types of committees, their potential responsibility and authority, and who must serve on them. And the biggest change was around those that can exercise authority of the board of directors. So this is an area that a lot of nonprofits might have an executive committee that if, let's say your board only meets quarterly, it's a pretty large board, and there's something that has to happen in between those meetings, and the organization has to be nimble. So they might give authority to their executive committee to make decisions on behalf of the board that are official decisions. They don't have to go and get approval from the board. They can just make those decisions without the board. In order for that committee to be able to exercise that kind of authority, it has to consist only of current and former directors. It also must be a committee of at least 2 members. There must be 2 people on that committee, and 1 must be a current director. So you can't just have 2 former directors. Committee members for that type of committee must be appointed by the board unless the articles or bylaws provide otherwise. So sometimes with an executive committee, you might see the bylaws say, okay, these officers serve on the executive committee and maybe a past president. So that would be laid out in the bylaws. Otherwise, it's the board of directors who sets those committees. Unless the articles or bylaws provide otherwise, the committee itself cannot elect or appoint or remove directors on that committee. So it has to come from the board or from something in the articles or bylaws, unless the bylaws say no, specifically that committee can't do that. I know it gets a little convoluted when you say unless the articles or bylaws provide otherwise. You can still have, of course, advisory committees and committees that make recommendations to the board, and those don't have to meet these requirements. It's a good idea to have those consist of at least 1 director or a former director, and then it can be a variety of individuals. And there's different rules in the code to address those. And those have not changed substantially, so I'm not going to cover that today. Turning now to officers. Oregon 501c3, I'm sorry, not 501c3. Georgia nonprofit corporations must have a chief executive officer, a chief financial officer, and a secretary. Y'all have to complete the annual filing for your corporation on the Secretary of State's website. And it lists the titles of CEO, CFO, and secretary. And that's because that's what's required for the business code. And so we had a discussion that these titles should be the same, whether it's a business corporation or a nonprofit corporation. So the official titles now for those positions are Chief Executive Officer, Chief Financial Officer, and Secretary. And they are defined in the code, what those definitions are for those positions. However, your articles or bylaws can define them by another name. So for instance, in your bylaws, you might say, this organization shall have a chief executive officer, chief financial officer, secretary, vice president, assistant secretary, whatever else you might have. And then it can say, our chief executive officer shall be known as president or executive director or whatever the right title may be. And so that it's consistent across the board And that it's easier because Secretary of State's office gets tons of questions. Well, we don't know how to fill out this form. We don't have a CEO. So it makes everything much more streamlined and clear as to how this works. Your executive director may be your CEO now, but it may not be. And I'll talk about that in a minute. So continuing on, so the CEO and the secretary cannot be the same person any longer. And there's a reason for that. And that is when you go to the bank, sometimes somebody's got to certify somebody else's signature. So the secretary can certify that this is in fact the CEO's signature. But if the CEO and the secretary are the same, that's not possible. In addition, having separate individuals serve as those officer positions reduces that incapacitation issue that I mentioned earlier. In addition, the code now says that an executive director is an officer unless otherwise stated in the bylaws. Now, many of you don't have a CEO and only have an executive director. So you would then say our chief executive officer is known as an executive director. But some organizations have a CEO and an executive director, and that executive director may not really have an officer position. And if that is the case, then it must be stated in the bylaws that the executive director is not an officer because they're presumed to be an officer. And the reason for that is that most of the time, the executive director really is that chief executive officer position in a lot of nonprofits. And so we wanted to make sure that that executive director is given the fiduciary, must comply with all the fiduciary duties of an officer, including conflicts of interest rules, but also is now under the indemnification provisions that officers are entitled to under your bylaws.
Robin, we have a few questions that have come in that I wanted to run by you. One person is asking, can an organization that has co-executive directors have more than one CEO now?
There should only be one CEO for a corporation with that title. You wouldn't have co-CEOs. You might have a chief operating officer and a CEO. You might have a CEO, executive director, but there's not two CEOs of a corporation. It is the chief executive officer.
And one person is asking, can you define the legal definition of a director versus an officer? And I think this is going back to the board of directors, since this was asked just before you started the slide. And can an individual serve as both a director and an officer?
Yes. So a director is somebody who has been elected to serve or appointed to serve on the board of directors. They are a director of the corporation and they serve on the board of directors. And the board of directors oversees the strategic direction of the corporation. Directors cannot make decisions on their own and have no authority to sign on behalf of the corporation. Officers, on the other hand, have authority to sign on behalf of the corporation and bind the corporation. Nonprofits can do it very differently. You can have officers who are directors and are only and the only people that can be officers are directors, but that's not necessary. You can have officers that are not directors, and there's a lot of fluidity and flexibility there. In addition, sometimes you have organizations that'll have board officers, like a chair might be just an officer of the board of directors, but they're not a corporate officer. Corporate officers would be your CEO, CFO, secretary, and so on, who have the authority to bind the corporation. A board chair who might be an officer of the board, for instance, might just oversee the board and its operations. But there's a lot of flexibility there with how you want to define these different roles. Hopefully that answered that question. Did I leave something out, Sarisha?
No, I think you did answer that question. We do have a couple more questions. I'm just going to bring two up. And one of them is, can you address whether your comments about CFOs does this refer to a hired CFO, or is it only related to a role on a board seat, such as the treasurer?
Again, that's that same issue that we were just talking about. So whoever is the official officer of the corporation is the CFO. You can call them treasurer if you want. You might also have a treasurer of the board who isn't technically an officer of the corporation. And they're just, it's like a position on the board where they have a role, but they are not an officer of the corporation. They combine the corporation.
And I'll let you go ahead and move forward to the next slide, and then I'll share the rest at the end.
Okay. So moving on, a couple other things about officers. One is, as I mentioned before, that 51-1-20 applies to officers if they're volunteers. Still recommend D&O insurance. And we're going to get into indemnification later, which will really show why it's important to have that directors and officers insurance. Okay. Officer removal and filling of vacancy provisions. We clarified those as to who can do those things. So it kind of depends on who elects or appoints those people. The articles or bylaws can designate that only the board can remove and fill vacancies of officers. It can specify that a specific officer can fill those roles, or sometimes that officer might be appointed by another officer. So for instance, I've seen some corporations will have that the secretary can appoint an assistant secretary. And so if the secretary wanted to remove that assistant secretary, the secretary could do so. So it creates a level of consistency. Another factor was that the secretary, there are times where documents have to be attested to show that they were duly authorized on behalf of the corporation. And this is getting into complex business transactions and sometimes litigation. And it was clarified that the secretary is the one that can attest to that signature and that it was duly authorized. But that's not going to come up very often in day-to-day operations. All right. Now we're going to move on to the indemnification provisions. So indemnification is compensation for harm or loss. In general, a corporation may pay for the costs of a lawsuit against a director or an officer that involve their actions related to the corporation. The Georgia Nonprofit Corporation Code explains under what circumstances this can and must be done and who can make that decision. And I want to start out with that, who can make that decision. If you have a corporation that has members, one of the important new definitions that was added is that in order to make that decision on indemnification, you must be a disinterested member. And it's patterned after this definition of disinterested director. So if I am being sued as the CEO of the nonprofit for my work as an officer, if my sister is a member of the corporation, we're related. She cannot vote on whether or not, if members get to vote on this, and that would be in the articles or bylaws. She does not get to vote on whether or not I should be indemnified because there's a personal connection. If she was a director, the same would be true. She could not vote on that. And so this just adds that to the membership level as well as what was in the director level. In addition, there are times where I must be indemnified, and if the corporation doesn't give me that indemnification and I have to go to court to get it and I win, then I can ask the nonprofit to pay for my expenses to get that win. And all that can be done without a jury. And that's getting a little bit into the weeds and something that hopefully none of you will have to deal with. All right, turning to the next slide. we added an additional measure of director indemnification, which brings nonprofit directors in line with for-profit directors. So for-profit directors had more protections than nonprofit directors until these changes came into being. And if the articles or bylaws, a contract or a resolution states that the corporation can indemnify or obligate itself to indemnify a director who is a party to a proceeding, and this is where it kind of gets confusing, so I'm going to break away from the words and just kind of explain it. Corporation sues me. I'm the director, I'm one of the directors, and the nonprofit sues me. The corporation can actually cover my expenses. They can indemnify me in this litigation, even though they're suing me, unless I lose. If I'm found liable, then I either have to pay it back if they advance the expenses, and if I win, then they reimburse me. And you would say, well, why in the world would a nonprofit want to do that? Well, there's a lot of directors that don't want to serve on a board if they're concerned that the nonprofit they serve for could turn around and sue them. And so that's what this provision is about. You do see it in for-profit corporations, and you do see it in nonprofit corporations. So it is a provision that is one that many directors may want to see. In addition, provisions can be put in the Articles of Incorporation that the corporation will indemnify directors and officers to the fullest extent of the law. And that is new as well. Any questions? I'll move on to disclaiming business opportunities.
No questions on indemnification, not yet.
All right, so disclaiming business opportunities. This is a whole new section, and this probably comes up more often in the for-profit arena than in the nonprofit arena. But basically, a corporation can say, you know what, we are not interested in this specific type of business opportunity. They can do it in their articles or bylaws or a resolution of the board. And then it reduces the number of conflicts of interest discussions that they have to have. And I'm going to give you a really good concrete example. Let's say the organization provides family visitation services in County A and only in County A. But let's say they have a board member who also works for an organization or as a for-profit business provides family visitation services, but they provide it in County B, C, D, and E. Well, if the board votes that passes a resolution or adds to their bylaws, look, we are okay with, and we're not going to go after any business opportunities of providing family visitation services outside of County A. Well, that means as a board member, we don't have to talk about the fact that I'm doing it in B, C, D, and E, those counties. And so it streamlines the conflict of interest concerns. And this really probably comes up more often in business associations and other situations where the organization, where you might have board members doing similar work, is the most likely where that's going to come up. But it was important to add to the code. All right, now amending articles and bylaws. A couple little changes here. First, and we talked about this already, basically proper notice has to be given to the directors before a bylaw amendment is to be approved, unless the articles or bylaws say otherwise. In addition, a corporation can now amend its articles or bylaws, and if you have members, you can modify members' rights, so long as it's not their vested property rights. So if members had a right to do A, and the board votes to change the articles or bylaws, and members may not have the right to change bylaws, so let's say it was in the bylaws, that the members no longer have that right, that's okay, they can do that, as long as it's not taking away some kind of vested property right. Some of these came up as very specific instances that these experts in the nonprofit arena were seeing on an ongoing basis. All right, turning now to amending to assets and distributions. So a nonprofit can sell or dispose of its assets in the ordinary course of business, in its usual course of its activities. If you're a membership corporation, you can now transfer the assets of your corporation as long as you still have control of them without getting member approval. So let's say I'm a membership corporation and I decide we want to drop this activity down into a subsidiary. We're going to control it, but we want to drop it into a subsidiary. Historically, you have to go back to the members to get approval for that. No longer have to do that where you have that control. Because you're not disposing of those assets, you're not, either giving them away or selling them, which would affect the membership potentially. So there's no need to go to the members for approval for that. All right, distributions. Distributions were not changed very much, but the section of the code was just really unclear. And so it was reorganized and reclarified. And so now distributions are clearly defined, and it includes, excuse me, corporations' assets, income, and profits. And that you cannot pay dividends or make distributions to members, directors, or officers. Also, what is not a distribution is also much more clearly defined. But we haven't made any changes to what those things are. It's just clarification. All right, moving on to records and reports, because I want to make sure I have time for all these questions that are floating in. Records and reports, a couple changes. One, right now, members have the right to access the books and records of a corporation. We added a restriction or a section that says that the corporation can impose restrictions on confidentiality, use, and distribution of those records by members. In addition, we added an inspection right for directors. As we talked about earlier, directors have a duty of care and a duty to have knowledge about what's going on with the organization. Well, they didn't have a right to inspect the books and records, so we added that to the code. All right, now we're going to go through members, and there's a few slides talking about members. A number of our clients do not have members, but hang in there so that you can hear the answers to the questions because they may be helpful. So the definition of member was much more clearly defined. It must be defined in the Articles of Incorporation, and a member has the right to vote for directors. But just because you have the right to vote for directors doesn't make you a member. Delegates sometimes have that. There are certain persons who can nominate, appoint, or confirm directors. That does not automatically make them a member. And membership needs to be clearly defined in the Articles and Bylaws. Notice to members. Organizations will have lots of members, and members may move, they may become disinterested. And so we gave a reasonableness standard. If after 2 consecutive annual meetings, all notices to that member they've either been returned as undeliverable or couldn't be delivered, the corporation can now remove that member from its roles. If the member then in the future provides a new address, they would be reinstated. There may be dues owed and other things, but they can be reinstated. Next slide. Membership corporations can't, this is just a clarification. Membership organizations can levy dues, assessments, and fees on its members as long as the articles or bylaws authorize it. The amount can be fixed by the board of directors depending on whatever the articles or bylaws say. So there's a lot of flexibility here for the articles and bylaws to define exactly how they want to deal with member assessments, fees, and dues, and how the amounts are determined. They can also provide a reasonable means for enforcing the collection of the assessments and dues and so on. Right, membership meetings. Calling a special membership meeting, we've changed that. So currently, holders of 5% of the membership or any amount listed in the bylaws can be required to call a membership meeting, but it can't be greater than 25%, because the purpose of, you want to make sure that members are heard, and you want to make sure that you don't make that bar, oh, it's got to be 80% of the members, because they'll never get that to call a membership meeting. And members do have the right to be heard. So action by written ballot. Historically, it just said they have to have an opportunity to vote for a candidate. Well, now it says, or to withhold a vote for. So, and it's got to be each candidate. So if you're going to have members vote by written ballot, they have to have the right to vote for each individual candidate and to say yes or no. And that's a change. In addition, members can have an action without a meeting by written consent. And there's some changes there. And those changes are basically that the votes are going to be the same as what's required if you had an in-person meeting. So for instance, you've got 100 members. And if you had an in-person meeting, quorum is majority. So you have to have 51% to have quorum. Then to have a vote count and to have a decision made, you have to have a majority of those present at a meeting where quorum is present. So that means you have to have 27 people vote in favor, which would mean if you do a written consent, you have to have 27 votes in favor to pass it, to pass the resolution. Turning to the next slide. Membership meetings currently can be held partly in person and partly by remote communication. So you'll see some people in a room, maybe some people by Zoom or whatever remote communication they want to use. However, for membership meetings, corporations must provide the membership list. And they must make it available at the meeting. But they also, if they're doing it partly in person and partly by remote communication, must make it available to those who are participating by remote communication or their attorneys. But they also have to make sure it's confidential and it's protected. And if they don't do that, the members can sue and get, and the corporation can be charged costs for not doing that. Quorum has changed for members and membership meetings. The default is now majority, and that matches with the business code. It used to be 10%. However, your articles or bylaws can set your quorum. So whatever your articles or bylaws say can be your quorum. If you don't say anything in the bylaws, then it is majority. However, any corporations in existence before July 1, 2023, that don't say what quorum is for members are grandfathered to the 10%. So if you don't want 10% and you want majority, or you want 25% or whatever it is, you should amend your bylaws to set what your quorum is for your membership meetings. In addition, now it requires 1/3 of the voting power to be present in person or by proxy to vote on matters, anything that's other than normal course for a membership meeting. So members always get to vote on directors, and sometimes the bylaws will say members can vote on a bunch of other things. If it doesn't say that in the articles or the bylaws, and there's other things that the members are going to vote on, then you need 1/3 of the voting power present for that. All right.
Robin, we have a couple questions on that last part that I wanted to relay to you. One of them is asking very specifically, does the ballot need to say I vote yes or I vote to withhold, or is it sufficient if it just says yes, no? Does that have to be included in that?
The best practice would be to say yes, no, or abstain.
And for membership meetings, does partly in person and partly by remote communication mean that virtual board meetings are no longer permitted?
No, that's not true. You can do it entirely virtually. It's just for those membership meetings, and we're not talking about board meetings, we're talking about membership meetings. For those membership meetings that are being held, that happen to be held partly in person and partly remotely, that's really all about the membership list and making sure that it's available to those that are participating remotely. because that's an important aspect of a membership meeting, that they can see who's on the membership list.
Thank you.
Yeah, sure. This gets a little convoluted because if you don't have members, you don't really think about these things. But you've got 3 different categories here. You've got your directors and the board of directors and its meetings. You've got your officers and the requirements of being an officer. And they may be directors and they may not be. And then you have your members. And your members, for those of you that don't have members, are like, they sit in the place of shareholders, only they don't have any ownership over the corporation. But they get to make decisions about like who's on the board of directors. And they can make other decisions if the articles or bylaws say so. All right. And that leads right into this slide, which is that the articles or bylaws, and it just said articles before, which was frankly a mistake, I think. It was left out. So now it says the articles or the bylaws may define voting requirements for election of directors. And it also, as I mentioned before, allows dividing the members into classes to elect certain specific directors. We talked about that before. So we've now covered most of the operational changes in the new amended nonprofit corporation code. So what are our next steps on the next slide? All of these changes are currently adopted unless it specifically says it's only for organizations that are formed after July 1st of this year. We recommend that you review your articles and bylaws to determine whether or not changes are needed. And before I get into the rest of the slide, I'm going to take questions.
All right, so one of the questions asked has to go with directly to making those amendments and how are those amendments to be made. She asked, do we amend the actual articles with a document that captures all these changes and then just attach that to the current articles?
Okay, so articles of incorporation have to be submitted to the Secretary of State to become official. You can do a specific targeted amendment, which says Article 3, Section 2 is amended as follows. Article 4, so you can do it like that and then submit that to the Secretary of State for approval. Your board has to approve it. If you have a membership corporation, the members might have to approve it. You have to look at what your articles currently say and your bylaws say. Or you can do what's called an amended and restated articles, which is actually kind of my favorite approach because then it's all in one document and it reads really clearly and you don't have to go back through and look for different pieces and parts and it's all right there. And you can submit that more easily online through the Secretary of State to get approval. I do recommend, if possible, that if you are a Pro Bono Partnership of Atlanta client, that you reach out to Pro Bono Partnership of Atlanta, and you have to be an active client. We've heard from you in the last few years. We do recommend that you reach out to us to get help with this because the Secretary of State is a stickler for how you can submit these amended and restated articles of incorporation. And I believe we are going to be providing a link in the chat box, which will allow you to sign up for the opportunity for us to eventually get you some help. You know, we could be inundated. There's 85 people on this call, so we could be inundated with a lot of these projects, and we will do it as time permits. But if you are a PBPA client, active client, you can sign up through that link on the chat function. If you are not, reach out to your attorney and have them help you, particularly with articles of incorporation. And I do recommend it with the bylaws as well. Bylaws do not have to be submitted to the Secretary of State, but they do, of course, all of that has to be approved in the proper form based on your articles and bylaws. Other questions?
So we have a question going back to your slide about the board of directors and their meetings. If the directors cannot vote by proxy, does that mean that we can no longer include proxies to have a board quorum at a board meeting?
Correct. You must make quorum with people physically or on the phone or, you know, using any remote communication. So You can do it by Zoom. You can have some people in person, some people on Zoom, some people on old-fashioned conference call, but they have to be able to hear everybody and be able to speak. But everybody has to be there at that moment to have quorum, enough to have quorum.
And we seem to have several questions kind of related to your slide about officers. And for example, one of them is if a small nonprofit has a treasurer who is a board member, but they are not their CFO, but the organization uses an accountant, an outside accountant for CFO type duties. Then does that mean the treasurer should be named the CFO under state law, or the outside accountant, or neither?
So the outside accountant is probably not wanting to be an officer of your corporation. I highly doubt that. So your treasurer is your CFO under the law. Now you can call them treasurer, but they have the roles and responsibilities of the definition of treasurer as identified in the code. Officers gets really complicated because there's so many different ways to do it. But somebody who's outside your entity, who's really just managing the accounting for you, is not going to want to be an officer of your corporation. That comes with duties and responsibilities that they're not going to want. So that's probably what the person you call your treasurer. The first thing to do is decide, and this should be in your bylaws, must your officers be directors? If your bylaws are not clear, that's a decision that you should make. Must your officers be directors? And maybe not, and maybe just your treasurer, or as you call it, treasurer, your CFO doesn't have to be a director, because maybe there's someone who's willing to fill that role, but they don't want to serve on the board. They might report to the board. They might report to a treasurer who's not an officer, but has this position as treasurer, who then reports to the board with that information. There's a lot of different flexibility. Most organizations that we work with, the officers must be directors, and they like it that way. But there's a lot of flexibility there.
And this individual is asking, do revisions to the bylaws also have to be submitted to the Secretary of State?
No, they do not. Now, they do, both sets need to be, if you are a 501c3, both of those need to be submitted to the IRS with your Form 990. If you file a 990N, they don't.
And going back to board committees, can not current or former directors serve on a committee with board delegated authority, but without a vote?
So the committee must consider, voting members of the committee must consist of current or former directors. If you want to have someone who observes and sits in on those committee meetings, that's fine. But the committee must consist of those people. And you don't want to have somebody who isn't one of those people, who has speaking abilities, who can influence that committee substantially as though they were a director or they were a committee member, even though they're not officially a committee member.
And this is going back again to, there are several questions kind of about the officers and who's paid and who's not paid. If current bylaws do not name an executive director as an officer, is the executive director now an officer unless the board revises the bylaws to exclude the ED as an officer?
Correct.
And I'm trying to focus on the questions that are related to the changes in Georgia Nonprofit Code. There are a lot of great questions here, which I'll try to answer with other resources as well. But one person has asked, and as you mentioned before, Robin, can you once again clarify the difference between members and directors?
Yes. So a corporation can be a membership corporation or not have members. If you have members, those people serve in the equivalent position of what a shareholder would serve as in a for-profit business, except that they cannot they don't get any money from the corporation. They have no investment, financial investment, and they can't get dividends or any revenue from the corporation. So what their role is as a member is the sole official thing that they get to do is elect directors. And they can be given other responsibilities, but the sole thing that they must have a right to do is elect directors. They don't have to elect all of the directors, but a member has the right to elect directors. And so they kind of sit over and above the board of directors, right? So you've got your membership, and then you have your board of directors. The board of directors provides a strategic direction for the organization. They make the decisions about how the organization is going to operate, what policies and procedures it's going to enforce and have in position. And then you have your officers who actually do the day-to-day work, or they oversee the employees who are doing the day-to-day work of the organization and implementing those strategies and implementing those policies and procedures. Your directors act by consensus. An individual director cannot go off and sign a contract on behalf of the corporation. Only officers can do that, or people the corporation designates that are their agents. So in most cases, most organizations have executive directors and they're signing contracts. So they should be deemed officers, or at least an agent of the corporation. And so that's why now we've made it that they are considered officers unless the bylaws or articles say otherwise. Because in many cases, organizations have had their executive directors signing contracts for years, and they haven't officially listed them as an officer in their bylaws.
And we have one question here that's, is there a list somewhere of duties of officers versus duties of directors? We do have some resources on our website that outlines sort of the duties of directors and the differences between what staff and directors might do. So
directors and officers. So an officer can be also a director, but it's a very different hat. Officers have very defined roles. And if you read your bylaws, you should state what the roles are of the officers. And the code defines the roles of officers. But directors are not acting, you know, I had a friend of mine who once explained it this way. Your board of directors acts by consensus. So it's like, if you're thinking of a person, it's your head, your heart, the trunk of your body is the board. They can't do anything. Your arms and legs are your officers. And they do what your head and your heart and your body tells them to do. And so the center is telling you, what are we doing as an organization? What is our mission? What are our goals? And how are we generally going to get there? And that is the job of a director. And then it's up to the officers to sign the contracts, to engage in the activities, to hire the employees, to get those things done.
I like that
and then
analogy.
usually they hire the executive director or CEO who then manages all the hiring after that.
Well, I'm going to ask one last question here today. If your bylaws call the CFO a treasurer right now, do the bylaws need to be changed so that the title exactly matches what's in Nonprofit Code of Georgia, CFO?
They should be changed to say, you can keep treasurer if that's what you prefer, but what it should say is the chief financial officer of the corporation shall be referred to as treasurer by this corporation.
And it is 1 o'clock, so we are up for time. I will try to answer, or Robin or I will try to answer maybe a few questions here if you have a couple minutes, Robin.
I do.
Does the Georgia Nonprofit Code apply the same to churches as to other 501c3 organizations?
So it's not about 501c3s. This is about nonprofit corporations. So if a church is a nonprofit corporation, then it applies.
And so now a paid CEO who is running the day-to-day of the organization can they be on the board as a voting member?
They can be, but they don't have to be. Just because you're an officer, you don't have to be a member of the board of directors. And your bylaws can so state that.
And committee member question. If a committee recommends action to the board, I thought you said they don't have to be a director or former director.
Usually, if you have a committee that is making only recommendations to the board, there's at least one director or former director on that committee. You usually don't have a committee that doesn't have at least one director or former director. But the rest of the committee need not be a board member of any kind, whether current or former. So if you have a fundraising committee, for instance, and maybe that consists of some staff, it consists of some outside people who are interested in helping the organization, maybe it consists of one board member or past board member. That's fine.
And let me see. What is the minimum number of the board of directors for a nonprofit corporation?
For corporations formed after July 1, 2023, they must have, and they're a non-member corporation, they must have 3 directors or more.
And this will be my last question. If an organization currently has a grant that says that their CEO cannot be a board member and their CEO cannot be a board member and be paid, how would that apply now?
Okay, well, like I said before, your officers don't have to be board members. And so if your CEO is paid, they don't have to be a member of the board of directors.
Right. Well, Robin, this has been very helpful. Thank you so much. And I appreciate you sharing your insight and expertise with us. For our viewers today, a recording of this presentation and the slides will be available on our website probably next week. And if you are a current client of PBPA, please check out the link in the chat. And please use that to let us know if you need any help with updating or revising your bylaws based on all this information that Robin shared today. And thank you all so much for joining us today.
Thank you all.